Welcome to the Boulder Criminal Defense Lawyer Podcast. I'm your host, Elena Nicole, and today I'm here with Allison Gordon. Allison Gordon is a criminal defense attorney with a strong reputation in Colorado's juvenile defense community. She has extensive experience in handling cases involving young people at every stage of the legal process, and she's known for combining compassion with determined advocacy to help clients and their families navigate incredibly difficult situations. So, Allison, thanks so much for being here today. I'm looking forward to this conversation.
Thank you so much for having me.
So let's walk through what actually happens once a juvenile enters the court system. What is the standard of proof needed in a juvenile trial for guilt?
That's a great question, and that's something that I think people often question. It's very important to understand that children have the right to be proven guilty beyond a reasonable doubt, just as adults do. Whether it's a trial to a jury for a more serious offense or a trial to the court for a misdemeanor, juveniles have the absolute right to be proven guilty beyond a reasonable doubt as to each and every element of the charge against them, just like an adult.
Yeah. And who usually decides what charges to bring against the juvenile?
That's a great question. And so the court process for juveniles is relatively similar to the court process for adults, wherein a police officer or a school resource officer who is a police officer is the person investigating an allegation and then referring the case for charges to the district attorney. And then the district attorney or the prosecutor is the individual who decides whether charges should be filed, and if so, what those charges should be. Now, the reason I say it's generally the same is because something that is prioritized in the juvenile system is diversion. And diversion is a program by which the juvenile's case can be diverted or moved out of the court system for a flexible or informal adjustment. And so the juvenile would receive counseling, would perform community service through taking accountability for the charges against them without pleading guilty and without receiving an adjudication. And if the juvenile successfully completes the diversion program, their case would be dismissed and expunged. In some jurisdictions, a very large amount of cases are referred to diversion, and if a case is referred to diversion, it may never go in front of the prosecutor at all. It may be referred by the law enforcement officer directly to the diversion program. And that's more common for juveniles than it is for adults, because the purpose of the juvenile system is rehabilitation and access to services. In Boulder, I have heard that 2/3 of cases are diverted before they ever reach the court system. And I think that's extremely admirable because it keeps juveniles away from the inherent trauma and stress of being hauled into the court system. On the other hand, a more informal and flexible resolution like diversion may not bring to light any violation of rights, any problems with proof, any issues with the investigation that took place. And so while there is a benefit to an informal resolution such as diversion, the fact that a diversion case may never go in front of a prosecuting attorney at all could mean that a juvenile is facing consequences like participating in diversion for a case that never could have been proven beyond a reasonable doubt at all.
Interesting. Yeah. I was going to ask if you have any knowledge from your experience or data on cases that went to diversion versus cases that end up going to the court process when it comes to repeat offenders. Like, have you seen anything on, are there more, are there less, depending on which way it goes?
That's a great question. And I think the stated purpose of diversion is to reduce recidivism, because once a child and any person is brought into the court system, being subject to an adversarial process, spending any time incarcerated, engaging in probation, just being court involved, that stigma can cause recidivism. Studies do show that the greatest indicator of whether somebody will commit a crime in the future is whether they've been accused of committing a crime before. And so the purpose of diversion is to keep children out of it. From personal experience, I would say it's difficult for me to say because, as I mentioned, many diversion cases are pre-filing. So those cases go into diversion before any attorney ever sees them, including the defense attorney. I am hopeful that diversion programs, especially the robust diversion programs that are in well-funded metro areas, do help children not recidivate, do connect them with therapeutic services, pro-social activities, vocational training, which make it less likely that they will find themselves in the system in the future. But I think that data would need to be collected by the district attorney's offices who are administering the diversion programs.
Absolutely. I was just curious if you had ever seen or heard anything kind of in that area. And just to help listeners understand the process a little better, how does the juvenile court process differ from the adult criminal justice system?
That's a great question. And I think that from the outside looking in, some things can be very similar. And because things have the same name, but they mean different things. For example, a juvenile is also released on a bond. But when you're an adult, your bond is money. You have either a personal recognizance bond, which is an amount of money you only need to pay if you don't come back to court, or a secured bond, which is an amount of money you need to pay in order to secure your release. Juvenile bond is not monetary. Juvenile bond includes conditions such as cooperate with pretrial services, take a mental health evaluation, take a substance use evaluation, wear your ankle monitor. And in juvenile court, your conditions of bond can be go to wrestling practice, help your mom make dinner twice a week, because following home rules is part of every juvenile bond. And so from the outside looking in, you'd say, well, you have a bond, it's the same. But a juvenile bond is so very different from an adult bond in terms of what it really means and how it really functions. And so the court process in terms of how charges are brought, your entitlement to a preliminary hearing, the motions hearings and legal issues that can be brought out, those things are very similar. But along the way, the judge will ask, how are your grades? Are you getting along with your siblings? Have you applied for any jobs? Have you gotten your permit? And all of those things come into play in the juvenile courtroom in a way that they don't come into play in the adult courtroom, because it really is about the whole human. And so while you're fighting this criminal case, while you're arguing about whether a search was improper under the Fourth Amendment, while you're arguing about whether an interrogation was coercive or involuntary, at the same time, as your lawyer, I'm going to ask, would you like a mentor? Are you interested in signing up for boxing? Do you like making music? Have you heard about the studio you can go to and rap with your friend? All of that matters very much in juvenile court. And so while your rights are the same, while juvenile court is, just like any other court, about fighting for your rights and fighting to show that you are not guilty beyond a reasonable doubt, at the same time, it is very much about showing the court and the prosecutors who you really are, how you got into the situation you're in, how it can be prevented, and who you're going to be in the future.
Yeah. How do you see that differ between a child, say, who's 10 to 13 versus more like the 15 to 18?
That's a great question. First of all, when a child turns 18, even if they are still in juvenile court, different penalties become available to the court. And so if you have a juvenile case, you're charged when you're 17 and you turn 18, you can be sentenced to adult jail. You can be sentenced to a halfway house or community corrections. And if you have prior cases and are subject to sentencing enhancers, it could be for up to 2 years. And so juvenile judges always want to believe in the potential that every child has. But if you're a child who served your first commitment to the Division of Youth Services when you were 12, 13, 14 years old, and you've received those services, and now you're back in court, you were 17, you turned 18, it's more likely that you might be sentenced to jail or community corrections than to have another chance at the Division of Youth Services. I think with a very young child, there is a lot of measures that are taken to avoid a commitment, with the understanding that those children are vulnerable, physically vulnerable to peer influence. But as a child gets older, and especially if they start to see the same judges over and over again in their home jurisdiction, a judge may believe that the only way to help that child is to commit them to the Division of Youth Services for a period of time.
Yeah, absolutely. That makes sense. And what is a detention hearing in juvenile court? Can you walk us through exactly what that looks like?
Absolutely. A detention hearing is the first hearing that takes place in juvenile court, and a detention hearing is about whether that child will be released under the supervision of their parent or guardian or remain incarcerated pending the adjudication of their case. The third option is that the child could be released to a placement that is not with their family. And a placement is what we might have thought of in the past as a foster home or a group home. A placement is usually a therapeutic setting where a child can receive services that they might not receive at home if they have significant mental health, substance abuse, or emotional needs. And so the detention hearing is the first opportunity for me as the criminal defense attorney to argue for what that child wants. Oftentimes that child wants to go home with their family, and that's what I'll argue for. Other times a child may not want to return to the living situation that they were in, and there may be an argument that they should be assessed for placement and for a therapeutic setting if home is not what the child wants. Very often, children do not screen into detention, and so they have a detention hearing, but they've already been released with a summons. Nonetheless, it's still a detention hearing, and at the detention hearing, the conditions of release will be established by the judge. So oftentimes a child has already been cited or given a personal recognizance bond, but comes to court for a detention hearing, and so there's no real question of whether they will be detained or released. We know they'll be released because they've already been released. However, the court may ask that they be supervised by pretrial services, that they take drug tests, that they attend school or work full time, that they go to therapy, that they attend a group, that they attend a pro-social activity, that they not use drugs or alcohol, that they have no weapons, that they follow a protection order. These are all examples of conditions that can be imposed to ensure the safety of the community at a detention hearing.
Yeah. And how long would you say on average a juvenile case takes from start to finish?
That's a really good question. Speedy trial for a juvenile is shorter than speedy trial for an adult. A speedy trial for an adult in a felony case is 6 months. All juvenile cases are 91 days. You would think that that would cause juvenile cases to move more quickly. And sometimes it is appropriate for there to be a quick disposition for a juvenile if they made a mistake, were subject to peer pressure, if it's something that doesn't repeat itself, if getting them under some kind of probationary supervision so that they can move on and expunge their record is appropriate. Some juvenile cases resolve quickly. Other times, it's very important for that juvenile to be stable before they take a sentence. And so if a juvenile is not passing drug tests, if they are struggling with their mental health, if they're running away from home, juvenile cases can drag on because it's very important for that juvenile to be in a stable place before they enter into a disposition, or else probation will not be successful. So I have certainly had juvenile cases that resolve at their second appearance. I've also had juvenile cases that go on for years because the whole multidisciplinary team of the guardian ad litem, pretrial supervisor, case consultant, case worker are working to connect that juvenile with appropriate services in order for them to resolve their case in a way that will actually work. In my opinion, there's no reason to just usher a kid onto probation who will be facing a revocation shortly afterwards if they don't have the tools they need to succeed on probation.
Right. Yeah, absolutely. Well, Allison, thank you so much for joining us today and sharing your insight on such an important topic. We really appreciate this conversation.
Thank
And
you.
thank you to everyone for listening. And if you found this episode helpful, make sure to subscribe to the Boulder Criminal Defense Lawyer Podcast. And we'll see you next time. Thanks again, Allison.
Thanks, Elena. Bye.
Bye.